So the contract of Industrial Court President Deborah Thomas Felix has not been renewed. She has been replaced by Heather Seal. But trade unions in Trinidad and Tobago are not at all happy about this. We do have on the line this morning President of the Federation of Independent Trade Unions, Joseph Remy. Mr. Remy, good morning.
Hey, good morning to you, Marlon, and good morning to all the ardent viewers and listeners of TV6. It's a pleasure to be here.
Of course, Mr. Remy. Mr. Remy, explain to us, what is this hullabaloo about concerning the appointment of Miss Heather Seal and not continuing with Deborah Thomas Felix as Industrial Court President?
Okay, Marlon, let me put some context to this, the unions, the federation's views. Mm-hmm. The issue is not on personality, and we want to make that elucidly clear. We have no issue with the personality of Ms. Seals, or we have no favoritism for the personality of Deborah Thomas Felix. Our issue is the process. This is an industrial court that was established to bring about equity and justice in the industrial relations environment. And the process that was used to remove or not to renew the contract of the then president of the industrial court is what the union is in contention about. And we want to contextualize that by saying the union has been on the forefront, making the call for the process to be re-engineered so that there should be some level of security of tenure for judges of the industrial court in the first instance, and that we should not have industrial court judges being appointed at the whims and fancies of the political directorate. This has been the union call way back, and I could recall Fitun leading the charge, even when President Carmona was in office, calling for the process to be relooked, because we were also of the view that they were going to remove the then sitting president of the court. And we raised these issues in the public space. And we are heartened now to hear the Law Association, who all of a sudden have found their voice in this industrial court environment, calling for the process of the appointment of the president of the court to be relooked. They are suggesting the Judicial and Legal Service Commission, and we are saying it should be relooked. And that has been the call of the trade union movement ever since. And we don't want there to be any perception of political bias or political interference in the process of delivering and dispensing industrial judgment in the working environment. And we have no issues with the personality. We have no issues with the incoming president. We want to make that abundantly clear, but we would have been calling for this process to be looked at ever since. And I think that is the context within which the trade union movement raised its concern publicly.
But how are judges of the industrial court appointed now? What's the process used?
The judges are appointed through directives of cabinet, which we have strong objections to. And there is no security of tenure. When your term expires, you have to wait and sit in abeyance, waiting for the cabinet to make a determination whether you could be reappointed or not. There is no process that could stand scrutiny in the public space, like how they appoint judges to the High Court. And let me also say, they must recognize that in the Industrial Relations Act, it was stated that the industrial court is a superior court of record. It must be given its prominence in terms of how judges are appointed. And judges now are appointed at the whims and fancies of cabinet. The president of the court is appointed by the president of the republic. And we all know that the appointments that are made by the president of the republic are guided sometimes by input from the political directorate. It has nothing to do with who is the sitting president. It has a lot to do with the process and how it was structured in establishing the Industrial Relations Act, and how they attempted to have some level of control over the process of the appointment so that there could be some control over the dispensation of justice at the industrial court. So we believe that that process should be relooked, and we are calling for that to be discussed at a tripartite forum, because the court is considered to be established on the basis of the strong input from the union. We could recall the very heinous days of industrial relations in the 60s, when there were a myriad of protests because of the fact of the way employers were treating workers. Workers were treated as slaves in those days. We still want to hold that view. And we had to fight to get an industrial court that would have bring about some level of equity and justice in the industrial relations environment. But there are still some vestiges of the colonial input where the cabinet has control over the appointment of judges, and we have strong objections to that process.
Is the way forward the suggestion that the Law Association has made, is it that these appointments to the industrial court should be made by the JLSC? You agree with that suggestion?
We agree with the process that there should be a relook. Whether it should be the JLSC or another arm, we believe it should be determined by tripartite consultation. There should be input from the three parties involved. The government, business, and labor should sit together and come to an agreement as to the process. And Marlan, this takes me back and takes us back to the breakdown of the National Tripartite Advisory Council, which we raised concerns. Those amendments to the Industrial Relations Act were some of the primary objectives of the trade union movement when we joined the NTAC. And we saw, similar to what is happening now, we saw they used NTAC as a means of political patronage. We made no objection to saying that. The reason why we moved out of NTAC was because it was still treated as an arm of government. It's a tripartite forum. Tripartism is not an arm of government. The government subscribes to the ILO, which is the International Labour Organization, which is the international tripartite body. They sit there and they agree to a lot of ILO recommendations and conventions. But when it comes to implementation and ratifying those conventions, they don't do it. Similarly, when we said at NTAC, let us review the Industrial Relations Act to talk about those things and to talk about the issue of security of tenure for judges at the industrial court and the process. NTAC broke down, and in the absence of NTAC, you will get those calls from the LATT, and they are within their rights to make that call. We have no objections to them making that call. Is it the JLSC or should it be another body? We believe it should be determined by tripartite consultation. That is what we are saying.
But you know, Mr. Remy, of course, Trinidad and Tobago is a small place, and there's the perception, there's the saying, well, everybody know everybody. So how are you going to put the correct checks and balances in place when even in the case of what you're suggesting, but even at that stage, everybody is familiar with everybody. So how are you going to create this sort of pristine process to have this done?
We don't anticipate perfection, Marlan. What we anticipate is some level of balance in the process. And you know, there is the perception when sometimes the trade union movement would have made a call. It is treated with some level of silence and it is dismissed. But because the Law Association is making this call now, because they residing in the Law Association as senior counsels, they may now be called king counsels, queen counsels, all different kind of counsels who are legalizing the industrial relations process. So they would want that process to be done through a legal procedure. We have no objections to sit in and let us put the merits and the demerits of what they are saying on the table and let us discuss it so that there could be some level of acceptance by all parties. We may not agree with everything that comes out, but at the end of the day, there is a level of acceptance by all parties. You can't please every Trinidadian in this process, Marlan. But what we would want to strive for is some balance of justice. Justice is supposed to be balanced on a scale. And what we are seeing now, it is tilted heavily in favor of the authorities who controls the purse. And that is the imbalance we are talking about, and that is the balance we are striving to bring back to this environment at this time.
Yeah. Is this situation concerning the industrial court, is it a fait accompli?
Well, in terms of the appointment of the president, yes, the president of the republic has the authority by law to appoint who she believes is fit and proper. That's the president's perception to sit as the president of the industrial court. It is enshrined in the Industrial Relations Act. We accept that. It's not that we don't accept that. What we believe is that the amendment to the act is what we have been calling for quite some time. And the amendment of the act should bring about a more transparent process. What was the criteria that was utilized for not allowing the sitting president to continue when there was a legitimate expectation of her continuing office because of the time it took for the president to notify her of non-continuance of a contract. Those are the critical industrial relations issues that we talk to. Those are the issues that the court have jurisdictions over. When we, in contract law, when we raise issues of employers not renewing contracts based on legitimate expectation, it is adjudicated upon by the court. And it is ironical that the same process that the court adjudicates on is the same process that we are questioning in the reappointment of the president. And those are the things that we are concerned about. So yes, the president is appointed. We would want to give the support to the incoming president of the court, but we are raising the same situation could occur with her. When her term expires, she could be subjected to the same treatment as what happened to Ms. Deborah Thomas Felix. And that is what we are raising concerns about. It's not about the personality. It's about how do we do things to ensure that there is some level of transparency in the public domain. Is there a process for disclosure of the rationale for non-renewal of a contract when there is a legitimate expectation? Those are the issues we want to raise in the public space.
Yeah. So following the appointment of Ms. Seal to the post of President of the Industrial Court, a statement was sent out. The statement said Ms. Seal is an extremely experienced member of the Industrial Court, having been a member for almost 20 years, since 2004. She holds a master's degree in occupational environmental safety and health and a Bachelor of Science degree in sociology from the University of the West Indies. She also holds an LLB degree from the University of London and is a certified mediator. So I say that to say, Mr. Remy, so you all, the members of the trade union movement, have expressed your concerns about the way the appointment was done and the process. Are you all now prepared to work with the new president of the Industrial Court? And are you all familiar with her? And are you also familiar with her experience and education and so on?
We are fully familiar with the new president's track record in the Industrial Court. She has been there for over maybe close to 20 years, if more than that,
yes,
which is correct. And she has the requisite qualifications. She was a sitting member of the court bench. So it's not that we are not familiar with Ms. Seal. And we wanted to be clear, we have no issues with Ms. Seal. The issue is not with the incoming president of the court. So we want to make that abundantly clear. The trade union movement has indicated, and you have seen statements coming from the NATOC president and also from JTOM, that we are prepared to continue to work with the incumbent president of the court. The trade union movement will continue to work with the incumbent president of the court, but the trade union movement will continue to agitate for the process for the reappointment of the president be relooked, because Ms. Seal, as I said earlier on, could suffer the same consequences of Ms. Thomas Felix. So yes, we are prepared to work with her. We will give her all the requisite support that is necessary, and we hope that she continues with the excellent work that was done by Ms. Deborah Thomas Felix. She has brought a level of stability to the operations of the Industrial Court. She has instituted some practices that brings about some level of equity. And let me say, to dispel something I saw from an industrial relations or so-called industrial relations consultant, I make it publicly clear that they want to rubbish the trade union call in terms of Ms. Seal. But let us be clear, because of the perception that Ms. Thomas Felix was biased towards the trade union movement, that is abundant, that is real foolishness. We have raised issues with a lot of judgment that came out of the court. And when those things were explained and clarified, the trade union movement humbled and moved on and tried to correct those shortcomings we saw in what was highlighted in the judgment. On the flip side, every judgment that goes against the employer, they call about the bias of the president of the court and the court. They don't see it as equity. What they want to see continue is the treatment of workers as hewers and drawers of wood and water. Those days have gone where the Masters and Servants Act was predominant in the dispensation of industrial relations justice. We have moved into a modern era, and we would want to see the continuation of equity and balance of justice that is dispensed from the Industrial Court. So we are going to be working with Ms. Seals. We are going to be giving her all the requisite support, and we anticipate a continuation of the lifting of industrial relations jurisprudence in Trinidad and Tobago, which will be the hallmark of the work that was done by the previous president and will continue to be the hallmark by this current president once we see that effort is being made to bring justice to the table.
But have members of the trade union movement, have you all relayed your concerns officially to those in authority? And what has the response been?
Marlan, for eons, and Adam said this is not of recent vintage.
Yes.
This is, the old models, because we have been doing this for quite a while. We have written to the President of the Republic, not this president, other presidents of the Republic. We have written to the Prime Minister. We have written to the Ministers of Labor. We have written to every possible person. We have raised it at NTAC officially, because NTAC was an established body by cabinet. We have raised it at every possible forum in terms of the amendment to the Industrial Relations Act. And I want to ask, where are the amendments to the Act that would have been recommended by the Industrial Relations Advisory Committee? That is an institution that was set up under the Industrial Relations Act. There have been some proposed amendments. Where are the changes to the policy that will treat domestic employees as workers, which has been a recommendation ever since? I want you to ask who have been challenging those things. It is the employers. They don't want to see those amendments in place because it is going to expose their nefarious industrial relations practices. So there have been suggested amendments to the Act, but there are persons who are opposed to those things because of how it will bring about a more balanced industrial relations environment. It is not the trade union movement who is challenging or objecting to the amendments to the Act. It is the employer class who is objecting to those things. You know why? Because they would not want to see a more balanced industrial relations environment. They would want to continue to dismiss workers and treat workers with impunity and continue to treat them like if they are their subjects. And I think we are in a different environment where we would want to see these things change. So we have been making these official calls over 20 years now. It's not of recent vintage.
Yeah. Joseph Remy, it's always good to see you and speak with you. Thank you very much and have a good Christmas.
Same to you, Marlan, and same to your staff, and same to all the listeners of Trinidad and Tobago. All the best to the new year also.
To you too. Okay, bye for now. So it's time for a quick break. We do have this image for you. It's captioned Speyside, Tobago from V. Alexander. Alexander, a beautiful picture there. I feel for a dip. We're coming back, everybody.